afternoon, Your Honors. My name is Emma Ray Tennant. I'm of the Nashville Public Defender's Office. I'm here on behalf of my client, Mr. Devaunte Hill. I would like to reserve 3 minutes of my time for rebuttal. This case was a large case. We raised 8 issues on appeal. There were most of those issues dealt with trial court's decisions on evidence, matters the jury heard that we believe they should not have heard, matters that were kept from the jury that we believe they were entitled to hear. As this court reviews this large record, I'd ask you to note how hard fought many of these issues were. Many issues went to reconsiderations of motions, bench conferences, more hearings during the trial. The state and the defense fought very strenuously on these very issues, on matters that the state now calls harmless error, but now were fought for strenuously below. Today, I just want to focus my argument on 2 of the evidentiary issues. First, the trial court's decision to admit proof of a prior bad act of my client, a shooting that was unrelated, that had taken place several years before, after it found that Mr. Hill opened the door to this testimony during his direct examination. This was proof that had been deemed inadmissible prior to trial. The state conceded its inadmissibility prior to trial, and no argument or case was made at that decision state whether it would be admissible under one of the enhanced relevant factors under Rule 404B.
But the ruling was, though, it could be admissible if the door was open during cross-examination, as I recall.
Absolutely. The court did point that out in that ruling. The second issue, just to preview for the court, that I want to get to is the admission of proof related to Mr. Hill's membership in a gang, where there was no evidence that this crime was gang-related, that there were other far less prejudicial ways to establish what the state claimed it needed this evidence for, and that the trial court used the wrong standard to weigh the admissibility of this evidence. I won't be able to address likely the other 6 issues we raised in our brief, but I do welcome any questions about those issues. For opening the door, State v. Vance, a Tennessee Supreme Court case from 2020, tells us that this doctrine only comes into play if the jury has been reasonably misled by some statement during testimony. During Mr. Hill's testimony, he told the jury that he did fire the gun that killed Miss Caitlin Coughlin. He testified as to his state of mind at the time of the killing. He addressed this point 3 or 4 times across 3 pages of his direct testimony, and in every instance, what he told the jury was he was not thinking, that he should have recognized the danger, but he was not thinking. At no point did he ever say he did not know that his actions were dangerous. Nevertheless, at a subsequent bench conference, the state formed that sort of version of his testimony and told the court that what he had said was that I should have known that, I didn't know that. I'm quoting the state here. He has been saying he did not know that he now knows. Ultimately, the trial court agreed with that interpretation of Mr. Hill's statements and made a ruling that he had made a sweeping claim that he did not know that by firing his gun he could have hurt someone, and allowed questioning on the issue of his prior unrelated shooting during the state's cross-examination. In 2007, the Tennessee Supreme Court ruled in a case called State v. Reels that context matters in these decisions. And the 2 points I really want to drive home on this issue today are a jury has to be reasonably misled, and that context matters. When a judge is evaluating whether a comment opens the door, it can't just look at that comment in isolation. It has to look at what the meaning is in the context of the testimony itself and in the context of the case. And because context matters, I do want to point out that when the state addressed this issue in its brief, it did not provide much context for the statements it argued opened the door. On page 29 of the state's brief, the state quoted Mr. Hill as saying, simply, "I should have known that I could have hurt someone or that someone could have been injured." But prior to that sentence, Mr. Hill had been setting the stage for saying, "I wasn't thinking." And even in quoting that sentence, it's incomplete. The actual full sentence that Mr. Hill said at that time was, "At the time, I wasn't thinking anything, but I should have known that I could have hurt someone or that someone could have been injured." So that comment came after several other comments in the same vein, which were, "I was not thinking," and which were not, "I did not know." Context matters because that's what the jury actually heard, and the jury has to be reasonably misled before this doctrine comes into play. This should not ever be a gotcha situation where you just hear enough to open the door. It should be in context with the whole case. Is it ever reasonable to think that an adult would not know that guns are dangerous? I don't think so. But even looking beyond Mr. Hill's direct testimony, the jury, at the time they heard those statements, which were never, "I didn't know," but were always, "I wasn't thinking," the jury had already heard proof that Mr. Hill knew that his actions were dangerous. During the state's case, the state introduced evidence from Detective Chad Gish that shortly after the crime, before it was publicly known, Mr. Hill was looking it up on his phone. He was searching for information about it. And as he explained in his testimony shortly after the comments in question, he did that because he knew, because he understood that his actions were dangerous. Context matters because the jury had heard all of that by the time the trial court made the decision that those comments opened the door by suggesting that he did not know that his actions could have hurt someone. The state established that he did know that. He searched it on his phone. He never said, "I did not know."
Well, I'm going back and looking at your brief where you do have more of the context to that exchange, is what I'm trying to say. And on direct, just before that statement was made, the question was asked, "Do you not realize that's dangerous?" And he responded, "Yeah, like as of now, well, I should have known that it was dangerous, but like I said, I wasn't thinking at the time." That seems to be saying then that at the time he didn't know it was dangerous. Maybe I'm wrong about that, but that seems to me what he's saying is, I didn't know at the time it was dangerous.
When I look at that comment, Your Honor, in light of everything he said in those 3 or 4 pages of his direct examination, it was always, "I wasn't thinking, I reacted, I should have realized, not that I did not know." I think that again, context matters, and we have to look at the whole thing, which also includes, I would suggest, proof that he did know, that given the cell phone records. Was the jury reasonably mistaken at that point when he really never said, "I did not know"? And by the time he uttered the statements in question here, the jury had heard all of the proof of that. I suggest the jury was not reasonably misled by Mr. Hill's statements.
And then the proof, just so I'm clear, that the jury here heard, based upon that comment that the state was allowed to bring out, I guess in rebuttal, was that he had fired a gun at and injured his grandmother.
Yes, and
two young relatives. Okay.
That's correct. Yes, that came towards the end of the state's cross-examination of him. The state was allowed to elicit that testimony.
On his cross-examination.
Yes.
Okay.
The The bench conference came, I think, during his direct examination, and then on cross, the state was allowed to ask those questions. And then, even though that had been considered inadmissible prior to trial and was really never evaluated under 404B, another thing that I wanted to point out, and I think this is troubling with opening the door cases, I couldn't really get clarity from the case law on what should happen here. But that testimony, that proof about the prior unrelated shooting, was evidently admitted as substantive evidence, and that seems incorrect to me, that having never been evaluated under the admissibility standards of 404B and coming in only to clear up purportedly some misunderstanding of the jury, to sort of even the scales, I guess, it was then allowed as proof of substantive evidence, and we know that because that is how the state argued it in its closing remarks, where it said, the state sort of used that as guilty knowledge evidence, saying that proof came in to show because it's not like he didn't know what he was doing. I want to say that compounds the error because I don't think that it should have come in substantively at that point. Came in as something to address the jury having been evidently misled. We don't believe that, but as substantive proof, I think that that's troubling. I would ask this court to find that as the trial court held in Reels, the Tennessee Supreme Court held in Reels, when a trial court misconstrues the meaning of words that are found to have opened up the door, that is an abuse of discretion. I believe the trial court, taking everything in context, misconstrued the meaning of Mr. Hill's words. He did not say, he did not know that. A jury is not reasonably misled in this instance, and that this is reversible error, and this should go back for a new trial on this error alone. I also would like to talk about the admission of gang evidence. As you will see when you review this record, the state worked very hard to make sure that the jury heard about proof of Mr. Hill's gang membership, and the defense worked very hard to keep this proof out. There is no evidence in the record that this crime was gang-related at all. So what was the purpose of this evidence? Following a 404B hearing, the trial court held that the state could introduce this evidence for two purposes. One, to show how their key fact witness, Jaquise Merrill Odom, knew that Mr. Hill and his co-defendant, Mr. Cowan, were friends, and to show why Mr. Hill lied to the police about Mr. Cowan's presence in the vehicle at the time of the shooting. Those were the two reasons. Now, we know that gang evidence is prejudicial. It is considered character evidence and does have to be evaluated under the heightened admissibility standards of 404B, and trial courts should treat this type of proof cautiously because it is apt to paint situations in a more nefarious light than the evidence supports. Again, this was not a case that had any gang-related evidence to it. It was not a gang-based crime. But this proof can nonetheless summon stereotypes and images that are prejudicial. And as a result of this recognition, again, we view this evidence under the more exacting standards of 404B, not 403. In this case, after a 404B hearing, the trial court took the matter under advisement and allowed the proof in for those two reasons, but did not employ the mandatory balancing test under the pertinent rule. Instead, it employed the far less demanding standard under Rule 403, which states that a trial court may exclude evidence if its probative value is substantially outweighed by the risk of prejudicial effect. Here, the standard that should have been used is a must standard. It is a rule of exclusion, and the probative value was very low with this evidence, and it was easily outweighed by the prejudicial effect of the gang evidence. There was ample proof, other proof, non-prejudicial proof, to show that Mr. Jacques Merrill Odom knew Mr. Hill and Mr. Cowan were friends. He testified that he had seen them together. They were hanging out in a parking lot shortly after the crime in this case. He had seen Mr. Hill and Mr. Cowan's car several times. The jury heard proof that they were in touch over text messages and phone calls in the weeks before and the weeks after the offense. The state had established their friendship, and Mr. Jacques Merrill Odom knew that they were friends. I would suggest there's very little additional probative value as to why they were friends. Same thing with the other reason that the court let the evidence in, to show why Mr. Hill lied to the police to say that Mr. Cowan was not in the car. The state proved that. The jury heard that statement. It was not in controversy. He did absolutely lie, and I grant that that has some probative value. But why he lied has very little probative value when weighed against the prejudicial effect of the gang evidence. Whatever small amount of probative value that had, wrapping it up with connotations of gangs and the risk of prejudice that that entails, I believe is improper. I'm out of time, but if this court has any questions, I would like to address them now.
All right, thank you, Ms. Tiff.
Thank you.
General?
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the trial court properly exercised its discretion in making evidentiary rulings. It properly denied the motion for mistrial because there was no cumulative effect of errors and because the trial court properly exercised its discretion in imposing a within-range sentence. Unless this court has questions on the other issues that weren't raised by the defendant today, I will also leave those on brief. And I'll address the two issues that were raised today. But first, I want to provide a factual background to sort of contextualize the what I would call overwhelming proof of guilt that this court has to consider when analyzing these evidentiary rulings. So on December 3rd, 2020, the defendant shot and killed Caitlin Kaufman in a fit of road rage while riding in a car on Interstate 440. Police found several 9mm shell casings nearby. Roughly a week later, a friend of the defendant's went to the police and disclosed that the defendant had both confessed to the murder and in fact had given him the murder weapon. Police were able to recover the murder weapon, a 9mm, and connect that weapon as the weapon that fired the deadly shots. They also interrogated the defendant, and he ultimately confessed to at least being in the car when the shooting took place, although he gave a false name when identifying the shooter. But then at trial, he admitted to the jury that he was the murderer and alleged that it was a reaction because Miss Kaufman, quote, just like cut us off, end quote. Based on this proof, the jury convicted the defendant of second-degree murder. And on appeal today, we're discussing two evidentiary rulings. First, the defendant takes issue with the fact that the court allowed him to be impeached with a prior delinquency adjudication when he opened the door. And my friend on the other side said that there were 2 points that she wanted to leave you with, and I think those both matter. First is the question of whether the jury was, quote, reasonably misled, and second is that context matters. And those are important, especially under the lens that this court reviews these evidentiary rulings. This ruling...
How old was the defendant at the time?
The record would be more accurate. I think he was in his teens.
Still in his teens?
I believe he was still in his teens. I just, the record would bear.
So it hadn't been that long since the
It had not been.
juvenile,
it had not been a significant
juvenile
period of time.
adjudications. Okay, thank you.
No, Your Honor. But this court reviews this determination under the lens of an abuse of discretion. So really, we look at whether the court sort of went way out of its way or whether its decision was reasonable. And when we're looking at whether the jury was reasonably misled and what the context that matters surrounding the comment, it's important to note this court is left with a cold record of black and white words. And what the trial court had was live testimony. And it was sitting there watching the jury's reaction, watching the defendant's comments, listening to those comments, and not just the cold black and white words, but instead the inflection that were meant with it and the context that these comments came up with. And so once the defendant said that comment of, I should have known that I could have hurt someone or that somebody could have been injured, the court had that context and could hear the inflection and could see how it affected the jury. And so then the state went up and said, Judge, he's opened the door. And the court said, yes, based on my observations of this live testimony, I think he has in fact insinuated to the jury that he did not know. My friend on the other side makes a big point today that the defendant never said he, quote unquote, did not know that shooting a gun could have hurt someone. But what he did say was, I should have known, which inherently means, or inherently suggests that he didn't know. So ultimately, when this court is determining whether the court properly exercised its discretion, viewing the context and viewing the trial court having the boots on the ground to see this live testimony, it's reasonable for the court to determine that comment and the context in which it was given ultimately misled the jury into believing that the defendant was unaware of the fact that firing a gun could have injured people. And I do want to be clear, the question that the court allowed was for the state to ask whether the defendant, quote, had fired a gun directly at someone, not just one person, but multiple people, and that he has struck those people with gunfire and they were injured. And they were injured and seriously injured. So any additional questions or any additional commentary that the defendant might take issue with was not something that the trial court ruled on. And the fact that he did not object at the time to any additional questions renders those waived. So it's that one singular question that this court is reviewing. And again, viewing it in the context of everything that the defendant said and questioning or analyzing it under an abuse of discretion standard, the state submits that the trial court properly exercised its discretion. But even if this court determines that that was error, it was certainly harmless. Again, the proof was overwhelming. And in fact, the defendant told the jury in person that he was the one who fired the shots that killed Ms. Kaufman and that it was a reaction to her cutting them off. The jury was entitled...
Let me just ask you before it gets too far past. The way I understood the question that you just provided, nowhere in that question was a criminal offense or a conviction or anything like that mentioned. Is that correct?
That's correct. The question and this is quoted directly from volume 25, 1122, which is the trial court sort of saying, yes, state, this is what you can ask, was just about the fact that he had fired a gun before, fired it at multiple people, and that those multiple people were injured by it. So directly rebutting his claim that he didn't know or should have known that firing a gun could result in injury. So ultimately, that was a proper exercise of discretion, but again, any error is certainly harmless, where the defendant tells the jury that he fired the shots that killed Ms. Kaufman out of a reaction to her allegedly cutting them off. That is, on its face, second-degree murder. So to the extent that there was an error, it certainly was harmless. Unless this court has further questions about that, I'll move to the...
Can I ask one other question, too? So during the state's proof, before the defendant testified, the only thing that the jury had heard was he said, he told the police that he'd been in the vehicle, but he hadn't fired the weapon.
They heard the friend's testimony, Mr. Merrill Odom's testimony, that the defendant came to him and admitted, I fired these shots, I'm in real trouble.
Okay.
So
the jury had already heard that, but okay.
Yeah, the jury had heard the defendant's testimony, or the defendant's admission through
someone else that he'd done the shooting. Okay.
Correct. So on top of that, that's even more proof for why this would be harmless.
Got you.
But also the defendant today takes issue with the admission of gang membership. And at first, it's important to clarify what the proper standard of review here is today in front of this court. And the proper standard of review is an abuse of discretion because the trial court substantially complied with the requirements of Rule 404B. And I think it's important to note that language. This court doesn't mandate perfect compliance. It doesn't mandate specific compliance. It mandates substantial compliance. And here, the trial court held a jury out hearing as required. It found a material issue other than propensity, specifically to establish the relationship between the two co-defendants, the defendant and his co-defendant who was driving, and to explain the defendant's commentary when he told police that a totally random person had been the person to fire the gun. So that was a material issue that was other than propensity. The defendant doesn't even contest that he was in a gang, or that this wasn't proven by a preponderance of the evidence or clear and convincing evidence. Really what he takes issue with is the fourth requirement, which is that the probative value outweighs any risk of unfair prejudice. But this court has previously found substantial compliance where a trial judge used the exact same language as the judge did here today. And I'll point this court to State versus March. It's also, that's 395 Southwest 3rd, 738. Again, the court there found that the probative value of the evidence was not substantially outweighed by the danger of unfair prejudice. In making a 404B analysis, this court said the court substantially complied with the requirements of 404B. So because the trial court here substantially complied with the requirements, this court reviews that determination for an abuse of discretion. But regardless, under any standard of review, the admission was appropriate. The information was highly probative. Again, it explained the connection between the defendant and his co-defendant, the person who was driving the car. And it also explained how they knew each other and explained his refusal to identify the accomplice. So it's not just that the defendant's trying to get himself off, he's also trying to help the co-defendant, quote unquote, beat the rap because they are not just apparently family members, but also they're in this gang. It was highly probative. The risk of unfair prejudice was minimal. I don't want to rehash, but the proof was overwhelming, especially given the defendant's straight-faced admission to the jury. This was properly admitted. Any error was harmless, and removing gang affiliation would not change the verdict in any way. I believe those are the only two issues that were raised before this court. Unless there are questions on other issues, we ask that this court affirm the judgments.
All right, thank you. General Coleman. Ms. Tennant?
The whole point of the difference between Rules 403 and Rules 404B come down to that final requirement set forth in Rule 404B, which is that evidence of a prior bad act cannot come in if the risk of prejudicial effect there outweighs the probative value. The word used in that rule is must. The word used in its counterpart in Rule 403 is may. Those are incredibly different rules. It is a rare case where evidence is excluded under Rule 403. I've made those arguments several times before this court. They don't get excluded very often. Under Rule 404B, the calculus is very different, and that is why it is our position that the trial court did not substantially comply with that rule and seems not to have grappled with the diminishing probative value of the evidence the state sought to prove by introducing proof of Mr. Hill's gang membership when it allowed that evidence in. Without substantial compliance with the rule, this court's review of that decision should be de novo under State versus DeVos. As to the harmlessness given Mr. Hill's admission at the outset of his direct examination that he is who fired the shots and killed Ms. Kaufman, the jury was charged with all of the lesser included offenses of first-degree murder, all the way down to criminally negligent homicide, but including reckless homicide. And I believe that there was proof that he talked about during his direct examination that his actions were irrational and reckless. And I think that is something the jury could have considered, and it is part of the reason why we believe these errors in the admission of evidence that undermined his credibility were harmful errors and should be reversed. And with that, in light of these two errors that I've addressed today and the rest of the brief, we ask you to reverse this case and remand it for a new trial. Thank you.
Thank you, counsel. Good job, good briefs. And again, we'll take it under advisement. According to Judge Montgomery, we'll get these out in a few months,
Speak for yourself.
not weeks. All right, with that, we are adjourned.
All right.